Hey there, people. How you doing? They found me guilty, and I went to jail for 75 days or something like that. They sentenced me to 100. But while I was in jail, I had a lot of time to reflect, and I immediately filed an appeal. So any of you people out there who are fighting for your right to travel and stuff, go ahead and feel free to use any of this information that I've done research, and it's what I'm pushing for is the right to travel. The government has arbitrarily stole our freedoms one at a time, and we can beat them in the courts, and I know I can on the right to travel, and I can also assist by the information I know, sharing with you people on how to take our country back. But anyway, back onto this immediate issue I have at hand here is the appeal that I'm doing on my driving while license suspended, and this here is what the reading of my brief, and I'm going to go ahead and post it too on this YouTube video. Feel free, like I said, to use whatever you want on there. It's there. We got to get together. We got to make this work. The statement of the case. This appeal is on behalf of Brian Miner from the result of an unfavorable judgment on case number 42018319, delivered on the 30th day of June 2014 at the Benton County District Court on the grounds of the Republic of Washington, where the city of Richland alleged that on the 5th night of March 2014, the appellant did drive a motor vehicle in the city of Richland while his driver's license was suspended in the first degree. This appeal has been initiated due to the crassa ignorantia, which is gross ignorance, shared by the public safety officers, police, the appellee, who's a prosecutor, and the lower court administrators, who are the judges. And it instigated by their failure to ascertain the difference between an ordinary free traveler and the extraordinary paid driver. When a person receives no compensation, pay, rate, fee, or fare, he has no need to beg or apply for his right to travel by submitting an application for the privilege to drive. He is born with his liberty, freedom, and right to travel where he wills without begging for permission by applying for a license from any politic body or other to do so. You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by any human laws, rights derived from the great legislator of the universe, John Adams, second President of the United States. Now I'm coming into some definitions here. Well, my definitions are right out of their legal dictionary. It came out of Black's Law Revised 4th edition. I got every page number, and it's all written down there, except for this first one. The very first one is rights, and it's of the absolute right of individuals, and it comes from Sir William Blackstone out of the Blackstone Commentaries, which, if you've done any of the study of the law, Blackstone, he gets right down there at the beginning where laws beginning to be recorded through actual reading. It goes further than him, but that's where he's a real strong influence. But anyway, so this is the Absolute Right of Individuals by William Blackstone. I'll get a drink, just a little bit of a second. Okay, rights. By the absolute right of individuals, we mean those which are so in their primary state and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy whether out of society or in it. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them, for the end and intent of such laws being only to regulate the behavior of mankind as they are members of society and stand in various relations to each other. They have consequently no concern with any other but social or relative duties. Let a man therefore be ever so abandoned in his principles or vicious in his practice, provided he keeps his wickedness to himself and does not offend against public decency. He is out of the reach of human laws. Now that is just beautiful in its own. That's one of their guys. Now the rest of these words here, they're in an order, and first of all I'm coming into freedom, absence of restraint, the power of acting in the character of a moral personality according to the dictates of the will. Now I got liberty, freedom, exemption from extraneous control, freedom from restraint under conditions essential to the equal enjoyment of the same rights by others. Personal liberty, the right or power of locomotion, of changing situation, or moving one's person to whatever place one's own inclination may direct without imprisonment or restraint unless by due course of law. And right, taken in a concrete sense. Rights are defined generally as powers of free action, and the primal rights pertaining to men are undoubtedly enjoyed by human beings purely as such. Inalienable, the characteristics of those things which cannot be bought, sold, or transferred from one person to another, such as rivers and public highways and certain personal rights. Example, liberty. Now I got one of their RCWs here, and then right after it I break it down. And it's highway. It's RCW 4604197. Highway means the entire width between the boundary lines of every way, publicly maintained when any part thereof is open to the use of the public for the purpose of vehicular travel. Now I'm emphasizing words that I'm emphasizing on here too, because I want certain words to stand out that are remembered. Now highway, an easement acquired by the public, a free and public roadway or street, one which every person has the right to use. Free, not subject to legal constraint of another. Unconstrained, having power to follow the dictates of his own will. Way, a passage, path, road or street. In a technical sense, a right of passage over land. Vehicle, that in or on which a person or thing is or may be carried from one place to another. Automobile, a vehicle for the transportation of persons or people on the highway, carrying its own motive power. Travel, to go from one place to another at a distance. To journey, spoken of voluntary change of place. Traveler, one who passes from place to place, whether for pleasure, instruction, business, or health. Driver, one employed in conducting or operating a coach, carriage, wagon, or other vehicle. Apply, to make a formal request, usually in writing, for the granting of some favor. They're trying to give us a favor. When you apply for a license, go beg for a license. Beg so you can go take care and live and support yourself. Favor. This is right out of Black's Law Dictionary, too. Favor. An act of kindness or generosity, as distinguished from one that is inspired by regard for justice, duty, or right. See that? This is right out of their dictionary. Application, the act of making a request for something. So you're asking them every time you go and fill out an application for a driver's license or whatever, if they're going to give you permission to go down to the street, because right here is permission. A license to do a thing, an authority to do an act, which without such authority would have been unlawful. And then the license. Certificate or document itself, which gives the permission. So you gotta, when you get the little license, now you got permission. Okay. Now I'm going into the USC titles, because the USCs are pretty important, because every state receives federal funding, so their laws apply. And so USC Title 18, Part 1, Chapter 2, Section 31. Number 6, motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property or cargo. And then it's emphasized used for commercial purposes, and you look and see what that says, used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or any other undertaking intended for profit. Wow, if that don't say that every driver is getting paid, they think. Okay, and then you got your USC Title 49, Chapter 3, Section 390.3, the general applicability. And it goes, you go down to F and its exceptions, and unless specifically provided, the rules in this subchapter do not apply to, this is under exceptions. You go down to number 3, the occasional transportation of personal property by individuals, not for compensation nor in the furtherance of a commercial enterprise. Yeah, that makes a lot of sense, don't it? Now let's go down here to the USC Title 49, Chapter 3, Section 395.2 in definitions. Driver means any employee who is employed solely as such by a private carrier of property by commercial motor vehicles. Driving time means all time spent at the driving controls of a motor vehicle in operation. And then you go to West 1990 Annotated Commercial Codes, Section 9109, Classification of Goods, Consumer Goods, Equipment, Farm Products, and Inventory. And you go down there under their Consumer Goods, if they are used or bought primarily for person, family, or household purposes. See, your automobile is a consumer good. It's not a motor vehicle, folks. Now you go into here to their RCW Title 62A2105 again, and its definitions, transferability of goods, future goods, and lot. And you go down there to their number 1. Goods means all things which are movable. Kind of seems like me, my car is movable every time I travel in it. Okay. Now, after we get through the definitions, it's the facts of the matter. While the appellant was on the inside of a lawful business conducting his essential personal and private affairs, the appellee's fact witness, policy enforcer hereafter, an employee at the City of Richland's Department of Public Safety who asserted this allegation by failing to engage the appellant and with no lawful warrant, said policy enforcer initiated an unlawful and unwarranted search on the appellant. Under the color of law, he completely exceeded his jurisdiction and violated the 4th and 5th Amendments of the Constitution of the United States, in which perspective and part reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no person shall be deprived of life, liberty, or property without due process of law." The Washington State Constitution, Article 1, Section 2 states, "The Constitution of the United States is the supreme law of the land." Now I go into the Book of Evidence, the Law of Evidence, Section 8, page 15, presumption in general. Presumption may be defined as to be an inference as to the existence of one fact from the existence of some other fact founded upon a previous experience of their connection. The inference is the the traveling and the driving. They're almost alike, but they're different. And that's the presumption. It is a common presumption and general misconception that a traveler and a driver are one and the same. The fact is, on one hand, you have the extraordinary driver who receives compensation from an undertaking while moving from point A to point B. Because he enjoys the extraordinary benefit of financial profit while accessing the public highways, he must ask for permission and obtain the privilege to drive upon them. He does this by submitting to the state an application for consideration of the privilege to drive. Once the consideration is complete, if acceptable, he must then pay a fee for the extraordinary decay that will be caused to the public highways due to his use of them for profit. On the other hand is the ordinary traveler, who receives no compensation while moving from point A to point B, but uses the public highway solely for the ordinary course of sustaining his basic, essential, everyday survival needs and pleasures. Because he uses the public highway solely for the purpose of sustaining his basic, ordinary, and essential needs for survival and pleasure, his fuel and tire taxes are the fees for the maintenance for the decay caused by his ordinary travel using the public highways. Since he causes no extraordinary decay to the public highways while using them, he is born with his freedom, liberty, and right to travel freely upon the highways. No permission, fee, or tax, or license is required. It's our right. It's our property. That is liberty, freedom, rights. People, come on. Now, number 2. Rather, what do, be it the policy enforcers' lack of education, failure to acknowledge, or inability to distinguish the difference between an ordinary traveler and the extraordinary driver, he reacted to traveling as if it were driving, and merely assumed without any proof that the appellant, while he was traveling, was engaged in the privilege of driving. Had said policy enforcer been properly educated and completed a thorough investigation, he would have requested either a bill of lading or a driver's logbook, both of which are required to be kept by a driver. He would also have concluded that the appellant was actually traveling, not driving, and the appellant was actually freely using his personal consumer good, my recreational vehicle, my automobile, and not a motor vehicle, while exercising his inalienable, common to all people right to travel upon a common way. No driver's license is required to travel. And when I say right to travel upon a common way, people, is any road that the post office delivers mail on is a common road, and it's a common way, and everybody has free access to that particular path. Period. That is plain and simple. You have free access to that path if you are not conducting commerce. Okay. Now number 3. The appellee's suit is based solely on 2 assumptions. See, if you don't know, every time you go to court you're being sued. It don't matter if it's a traffic court or what. I'll explain that in another video sometime, but anytime you're in court it's a lawsuit. Period. I'll get back to that on another video. The appellee's suit was based solely on 2 assumptions. First, there being a valid quasi-contract driver's license in existence that would sustain a suspension prior to trial without fortiori. That's without being told. It's already it's his duty to provide the proof, but I already did. The appellant provided the appellee and the lower court with the following factual information. On the 7th of May 2004, in order to enhance my employment qualifications, I entered into a driver's license contract to lawfully participate in the privilege to drive as a paid profession, the exact intent of the driver's license, in order to legally conduct commerce. Commerce is the only business of the free people's will government can lawfully regulate. When the term of the driving contract were due to expire and I had not engaged in the privilege under said contract, I elected to allow the contract to expire and become null and void. The driver license contract expired January 20th, 2009. No license contract exists. A thing that does not exist cannot be suspended. The fact is, there is no valid contract that will support this frivolous lawsuit. The appellee induced into evidence a certified abstract complete driving record from the Washington State Department of Licensing, which clearly shows the driver's license status to be issued on 5/7/04 and expired on 1/20/09. Thus again, by the appellee's very own evidence, the driver's license was expired. Solid, undeniable proof, the appellee's assumption of a valid contract to be false. And second, I challenge him with a law exists that can regulate free, which is an oxymoron, if you regulate free people's liberty or inalienable right to travel. Again, prior to trial, the appellee was challenged to provide the law compelling travelers to beg or solicit, apply by submitting an application, to obtain permission and pay a fee or a tax for a driver's license in order to lawfully conduct everyday basic essential needs, affairs, and or travels in the ordinary course of his daily existence. And he couldn't do it, and the judge sent me to court anyway. Now I get into Stevens Digest, Burden of Proof, Article 93, page 175, law books. I got a lot of them. He who affirms must prove. Whoever desires any court to give any judgment as to any legal right or liability dependent on the existence or non-existence of facts which he asserts or denies to exist must prove those facts do or do not exist. From the Law of Evidence, Article 96, page 180. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the burden of providing that fact should lie on a particular person. That's what that fortiori was about. The Law of Evidence, Section 8, page 23, Presumption of Innocence. There is no presumption more highly favored in law than that of innocence. Now, Although evidence adduced by the appellee was undeniable, solid proof the driver's license was expired and didn't exist, which voided the contract, the appellee failed to provide any variation of said law compelling travelers to beg or borrow for a license. The administrator at the lower court, rather than dismissing the allegation, moved forward and proceeded. Now, if Law A, travelers have to beg for a driver's license, does not apply, then Law B, driving while license suspended, cannot possibly apply when you're traveling. Now, this is my support. Article 4 of the Constitution of the United States reads in part, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made shall be the supreme law of the land, laws of any state to the contrary notwithstanding." Now, the Northwest Ordinance is a treaty, and it is the supreme law of the land, because when you look in the supreme law of the land, the Constitution, all treaties made on behalf of the United States become part of the Constitution. And so the Northwest Ordinance is a treaty and is the supreme law of the land. Article 4 reads in part, "The navigable rivers shall be common highways and forever free, without any tax, impost, or duty thereof." And then Article 2, Section 1. Article 2, Section 1, and Article 8, Section 3 of the January 28, 1889 valid state constitution, as approved by the 50th Congress Session Senate Miscellaneous Document number 50, which in perspective and part read, "The Columbia River and the navigable waters of the state shall be common freeways and forever free, as well to the inhabitants of the state as to the citizens of the United States, without any tax of impost, duty thereof. And all railroads in the state shall be deemed public highways and shall be free to all persons for the transportation of their persons and property." Blashfield's Automotive Law and Practice, 3rd edition, 1998, Chapter 465, Classification of Motor Vehicles. This is as late as, well, however you want to say it. This is in 2000, basically. The classification of a motor vehicle is based on whether they are used for business or commercial purposes, or merely kept for pleasure of family use, a license being imposed in one case and not the other. Washington's Business Law for Businessmen in part reads at Section 1351, Babbitt's Book 1364, "The law of the road highways are public roads, which every citizen has a right to use. The use of the highways is not a privilege but a right." Now I'm into the summary. I know this is pretty long-winded. The Republic of Washington's very own Supreme Court Justice Tolman's words say it best. "I am not particularly interested about the rights of haulers by contract or otherwise, but I am deeply interested in the rights of the public to use the public highways freely for all lawful purposes. Complete freedom of the highways is so old and well established that we have forgotten the days of the robber barons and the toll roads, and yet under an act such as this, arbitrarily administered, the highways may become completely monopolized if, through the lack of interest the people submit, they may look to see the most sacred of their liberties taken from them one by more or less rapid encroachment." That's in one of them law books. The most sacred liberties Justice Tolman was speaking of is personal liberty. Personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far as the rights of others make it necessary for the welfare of all citizens. The right to travel, or the right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering or disturbing another's rights, he will be protected not only in his person, but in his safe conduct. That's out of the Second American Jurisprudence, Constitutional Law, section 329, page 1134, if anybody wants to know. Now, we the people now hear those words prophetically ringing in our ears, as we the people did not take heed to Justice Tolman's warning. Today the public highways have become completely monopolized by the very entity in which we the people have entrusted to protect our rights and liberties and stand guard over our freedoms. The legislators do not own the highways, nor do they own the citizenry. Quite to the contrary, it is the other way around. They may appropriate the funds used to build and maintain the highways. They may choose a particular path. They may even oversee the construction of highways. However, those highways are paid for with tax dollars collected from the public, and the labor is directly provided by the public. The highways are owned by the public, hence the term public highways. It is ludicrous to think or believe for even just a nanosecond we the people would just stay home to die and rot if the government did not oversee the construction of the highways. Think back to times to the government when the government did not oversee the construction of the highways. Think back to times prior to government appropriation of funds, of we the people's taxes for overseeing highway construction. And the highways were built out of need by labor of we the people. While thinking that far back, one must remember horse theft. It is a crime punishable by hanging to death. The reason for this: to steal a man's horse, whether out on the range or in town, was to deprive him of the use of his modern mode of transportation, leaving him to possibly die. In essence, this government's ultra-vires, beyond their charter act of stealing our mode of transportation, is exactly what the legislators have attempted. Shall we stretch their necks for this arbitrary action? The government works for the people. Does the owner of a house ask the maid he hired for permission to use his bathroom? The answer is obvious, and true to the ordinary use of our public highways as well. Even though the government oversees the construction and maintenance of the highways, ordinary travel upon the highways are by right free for the owners, our public, to use for travel. If a person uses the public highways in an extraordinary manner by using said highways for profit, an example as a place of employment, then and only then does the government have right by charter to charge an extra fee or tax to said individual alone and others using the said highways similarly. The Department of Motor Vehicle regulates commercial activity. The Vehicle Code contains rules applicable to the business called driving and those engaged in that business. The license is evidence of the state's permission to engage in the business called driving. A driver is someone for hire who gets paid from point A to point B. A motor vehicle is a device used to transport passengers and or property for compensation. A cab driver, tow truck driver, UPS driver, FedEx driver, cattle driver, stagecoach driver all have the same thing in common. They get paid to go somewhere. This is the difference between one who uses his car for non-commercial business, non-business purposes, and those who use a device identified by the term motor vehicle or vehicle for commercial or business purpose. One gets paid, the other does not. The class of a person who identifies themselves as a driver are in a class for those engaged in commerce or business, going to court, the grocery store, the voting booth, the diner, the movies, the beach, visit family, friends, the doctor, the school, the church. It's not business, it's not commercial, unless you're getting paid. Non-commercial use of a car for everyday travel is not business, it is personal, and no driver's license is required for people to engage in personal, non-commercial activity. The conclusion, finally, the state did not give the citizen his rights and thus cannot take them at will. The state did not establish the settled maxims and procedures by which a citizen must be dealt, thus cannot abrogate or circumvent them at will. It is well settled that legislative enactments do not constitute the law of the land but must conform to it. The general misconception is that any statute passed by legislator bearing the appearance of law constitutes the law of the land. The Constitution is the supreme law of the land. Any statute to be valid must be in agreement. It is impossible for both the Constitution and a law violating it to be valid. One must prevail. This is succinctly stated as follows. The general rule is that an unconstitutional statute, though having the form and name of law, in reality is no law but wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely from the date of the decision so branding it as unconstitutional law in legal contemplation, as inoperative as it had never been passed. Such a statute leaves the question that it purports to settle just as it would be had the statute never been enacted. Since an unconstitutional law is void, the general principles follow that it imposes no duties, confers no right, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no act performed under it. Justifies no act performed under it. Wow. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing valid law. Indeed, so far as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no court is bound to enforce it. The very essence of civil liberty certainly consists of every individual the right to claim the protection of the law whenever he receives an injury. One of the primary duties of the court is to afford that protection. The court should not need to be reminded that the Washington State and United States Constitution are to be looked at as constitutions of government ordained and established by we the people to regulate and limit the power of government in order to prevent the encroachment on the rights, liberties, and freedoms of we the people. The state is founded on the relation of rights. Protection is its aim and its object. And that protection is but another word for justice, or the obtaining and granting every man his due. Man did not enter into society to become worse than he was before, nor to have less rights than he had, but to have those rights better secured. As the end intent of law is happiness and perfection of the general society of mankind, it enjoins upon everybody the punctual observance of benevolence and goodwill, as well as of justice towards his neighbors. Justice is of perpetual obligation and essential to the well-being of every society. No harm, no foul, no victim, no crime. It was 1776, in just 3% of we the people who banded together and initiated the start of the revolution against King George III for offenses very similar to those offenses being committed by the government of the United States today. Here is just to mention a few of them: for failing to adhere to the Charter. The Constitution of the United States of America is that charter. For employing large bodies of armed men, the police, who are free to protect agents and interests of government while prosecuting we the people for identical actions, and protecting them, the police, by holding mock trials conducted by their colleagues for any assaults and or murders which they should commit on the inhabitants of these United States. The encroachment on the rights and the liberties and the freedoms of we the people, for putting us on trial for pretend offenses in which there is no corpus delicti, mens rea, or actus reus, for imposing upon us taxes without our consent. A tax is a fine for doing good, and a fine is a tax for doing whatever government says is bad. The driver's license is a tax. Without one, if you do not know and exert your rights, you will either be jailed, fined, or both. Will a time come for the 3% of the current we the people to have the need to band? That is not for me to decide. That decision rests upon chosen administrators or who are in the position to administer justice.